Good morning and welcome to the Public Service Commission. Today is Tuesday, January 28th, and we are here today on docket number 2024-144E. First, a roll call of commissioners. All commissioners are present in the hearing room for today's hearing. I would ask Ms. Wessinger Hill to read the docket and tell us where we are.
Thank you, Mr. Chairman, and good morning, everyone. As the chairman mentioned, this is the hearing and proceeding as noticed by the clerk's office in docket number 2024-144E. It relates to the petition and application filed by Duke Energy Carolinas and Duke Energy Progress LLC, requesting approval of the 2023 solar and solar paired with storage resource procurement program. Mr. Chairman, all parties are present and the docket is in order.
Thank you very much. Would the parties, beginning with Duke, please introduce themselves?
Good morning, Chair Powers, Vice Chair Williams. I'm Nathan Haber on behalf of Duke Energy Carolinas and Duke Energy Progress. Joining me today is Sam Welburn, my co-counsel. Thank you.
Welcome. Carolinas Clean Energy Business Association.
Chair Powers, Richard Witt for SECIBA.
Thank you, Mr. Witt, and Office of Regulatory Staff.
Good morning, Mr. Chair, Mr. Vice Chair, and Commissioners. Chad Torrey. On behalf of ORS, I'm joined today by Ben Muschin and Stig Rasmussen.
All right. It's my understanding that the parties wanted to make, or that ORS wanted to make a presentation at the beginning as to the potential settlement agreement.
Yes, Mr. Chair.
All right, you have the floor.
Thank you, sir. Good morning again, everyone. Chad Torrey on behalf of ORS. As I believe the Commission is aware, on December 4th, 2024, ORS filed a settlement agreement in this docket for the Commission's consideration. The settlement agreement is between Duke Energy Carolinas, Duke Energy Progress, and ORS. And although not a signatory, Carolinas Clean Energy Business Association, the only other party in this matter, does not object to the settlement agreement. Mr. Chair, I would ask that the settlement agreement be marked for identification and entered into the record of this case as the first hearing exhibit.
The settlement agreement will be accepted and marked for identification and placed in the record as exhibit number 1.
Thank you, Mr. Chair. Commissioners, if approved, the settlement agreement before you would resolve all issues between the parties in this matter. This case involves the company's CPRE program. The companies first presented their CPRE program to the Commission in docket numbers 2022-239E and 2022-240E. That case, as you may recall, was the subject of extensive litigation efforts by the parties and involved motions, practice, and multiple rounds of pre-filed testimony. Yet, the parties were able to reach a settlement, which the Commission approved in February of 2024. We're here today in the company's second CPRE case. Like its predecessor, the second CPRE case was also the subject of fairly extensive litigation by the parties, as is evident from a review of the letters, motions, responses, and replies thereto filed in this docket. Ultimately, however, the parties made compromises from their original positions to achieve a resolution of the disputed issues. Commissioners, the settlement agreement before you today is substantially similar to the settlement agreement approved in the company's first CPRE case. For example, both settlement agreements provide that the company's CPRE procurement must be driven by an integrated resource plan or similar planning process. Both settlement agreements provide that the company's CPRE program is reasonably informed by the company's IRP or other resource planning process. Both settlement agreements provide that the companies have adequately followed the framework for implementing CPRE programs, resulting in a fair, open, transparent, and non-discriminatory procurement. Both settlement agreements provide that the CPRE is a reasonable step for the companies to take towards procuring renewable generation. Both settlement agreements provide that commission approval of the CPRE shall not equate to the approval of and shall not be used as dispositive evidence of 1. The reasonableness or prudence of any specific project activities related to the 2023 CPRE. 2. Future recoverability of specific items of cost related to the 2023 CPRE. Or 3. Pre-approval of any rate-making treatment. Both settlement agreements provide that the companies retain the flexibility and responsibility to prudently effectuate, complete, or abandon the 2023 CPRE and any of the projects set forth therein. And finally, both settlement agreements provide that the 2023 CPRE and its associated costs and project activities is conditioned on and subject to review by the Commission, ORS, and other interested parties for reasonableness and prudency during future appropriate cost recovery proceedings. In conclusion, the settlement agreement preserves the ability of ORS and other parties to conduct a full historical review of the known and measurable costs and investments resulting from the CPRE in a future cost recovery proceeding. And it expressly preserves the Commission's authority to determine what costs associated with the 2023 CPRE the companies are allowed to recover. Mr. Chair, thank you for your indulgence. Happy to answer any questions. I know the companies have testimony that will probably further flesh this out.
Thank you, Mr. Torrey. I know in the past, a couple of attorneys have felt like they pleading guilty when I ask these questions, but I like to ask these questions just to have them in the record. And I guess we're all wrong, then we are pleading guilty at some point. But if you don't mind, I'm going to ask questions and ask the parties just to respond in turn, and I'll just ask the question once, if that's okay. And I'll start with Duke. Do you feel that your agency had ample opportunity to participate meaningfully in this case, including engaging in discovery processes, pre-filing testimony, receiving and reviewing all relevant evidence, and complete disclosure of all relevant information?
Yes.
Sasiba?
Yes, Chair Powers.
All right. Mr. Torrey?
Yes, Mr. Chair.
Thank you. Did your client participate in any settlement negotiation in good faith?
Yes, Chair Powers.
SECIVA is not a signatory, but we do not oppose it.
Okay, thank you.
Yes,
Then I
Mr.
may
Chair.
just skip you on some of them then. Mr. Torrey?
Yes, Mr. Chair.
All right. Do you feel that your client has had ample opportunity to review the terms of the agreement?
Yes, Chair Powers.
Mr. Twitt?
Yes, sir.
Mr. Torrey?
Yes, Mr. Chair.
All right. And the decision to enter into this agreement as a signatory on the part of two parties is this decision reached voluntarily, not under undue influence or pressure?
Yes, Chair Powers.
Would you agree that Mr. Torrey?
Yes, Mr. Chair.
All right. Would you agree that the settlement agreement being presented to the Commission is agreement resolving all issues, and this would be, in fact, a comprehensive settlement agreement?
Yes, Chair Powers.
And you,
Yes, Mr. Chair.
Torrey, and you all realize we are here, the matter's properly docketed, and we got time to hear the whole thing if necessary.
Yes, Chair Powers.
Mr. Twitt?
Yes, Chair Powers.
Mr. Torrey?
Yes, sir, Mr. Chair.
Do you feel the settlement agreement is in the best interest of the utilities customers, and the best interest of the public?
Yes, Chair Powers.
Mr. Witt?
Well, I think we have to pass on that. As you said, some of them won't apply to
Right.
us.
Ms. Story?
Yes, Mr. Chair.
All right, thank you very much. If there's nothing else, we can proceed with the testimony.
Thank you, Chair Powers. Duke Energy calls George Brown, Tyson Grinstead, and Heather Shirley Smith to the witness stand.
Please come forward.
If you would all please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Thank you. Mr. Brown, could you please state your name for the record?
George Brown.
And by whom are you employed and in what capacity?
I'm self-employed. I'm a consultant for Duke Energy Progress and Duke Energy Carolinas.
Thank you. Did you prepare or cause to be prepared under your direction 23 pages of direct testimony pre-filed on August the 15th of 2024?
Yes, I did.
If I asked you all of the questions contained in your pre-filed direct testimony here today, would your answers be the same?
Yes, they would.
And do you have any changes or corrections to your pre-filed direct testimony at this time?
No changes or edits.
Chair Powers, I move that the pre-filed direct testimony of Mr. Brown be entered into the record as if given orally from the stand.
The pre-filed direct testimony of Mr. Brown will be entered into the record as if given orally from the stand.
Thank you. Mr. Brown, did your pre-filed direct testimony include one confidentially filed exhibit labeled Brown Direct Exhibit 1?
Yes, it did.
Chair Powers, I move that the confidentially filed exhibit labeled Brown Direct Exhibit 1 be entered into the record as the next hearing exhibit and remain under seal.
All right, so the pre-filed exhibit of witness Brown identified as Brown Direct 1, marked confidential, is marked for identification and placed in the record as exhibit number 2. The confidential version shall remain confidential as long as legally necessary.
Thank you. Mr. Brown, would you present your testimony at this time? A summary of your testimony?
Yes, I'd be glad to. Good morning, everyone. My testimony provides an overview of the 2023 CPRE program and explains how the program incorporates lessons learned from the 2022 CPRE program, stakeholder feedback, and follows the same framework of best practices that the Commission approved in Order Number 2024-144. In addition, my testimony details the post-solicitation report prepared by independent evaluator Charles River Associates, which concluded that the resources selected through the 2023 CPRE program RFP represent the highest ranked, least cost portfolio of options available to customers to achieve the target procurement volume. Section 1 of my direct testimony explains the company's development and execution of the 2023 program. I explained that the 2023 CPRE program is first designated to provide least cost renewable power. Number 2, aligned with industry best practices and the framework of best practices that the Commission approved in Order 2024-144. 3, designed to procure a reasonable balance of both third-party owned and utility-owned projects, both of which provide key benefits to the company's customers. My direct testimony also explains that while the 2023 CPRE program's design is similar to that of the 2022 CPRE program, it incorporates a few important differences. Most notably, the 2023 CPRE program sought to procure solar plus storage facilities in addition to solar-only facilities, and it utilized a resource solicitation cluster instead of the standard DICES interconnection process to facilitate the interconnection study process. Next, my testimony describes how the 2023 CPRE program incorporated each element of the Commission-approved framework of best practices, including by taking the following actions. Number one, we meaningfully engaged with stakeholders about the 2023 CPRE program over the course of 4 stakeholder meetings, 1 pre-solicitation bidders conference, 2 interconnection meetings for participants in the resource solicitation cluster, and many written exchanges. 2, we issued the RFP after stakeholder engagement, and we modified some of the final terms in response to stakeholder feedback. 3, we engaged Charles River Associates to serve as the independent evaluator and provide independent oversight of the 2023 CPRE program, ensuring transparency and fairness of the process. 4, we established a well-defined bid evaluation process to ensure that each proposal will be evaluated in a fair, non-discriminatory, and transparent manner. Number 5, we implemented a bid refresh process, volume adjustment mechanism, and other measures to control costs. 6, we ensured alignment between the 2023 CPRE program and the interconnection cluster study process. And finally, we also provided grid locational guidance, identifying transmission-constrained geographic areas to market participants to inform their future development. Section 2 of my direct testimony describes the results of the 23 CPRE program and the findings contained in the independent evaluator's post-solicitation report. Through the program, the company selected 1,457 megawatts of new solar generation. Out of the 1,457 megawatts, 18 projects totaling 1,412 megawatts accepted the company's award and executed contracts. Approximately 30% of the output of the accepted projects, or 413 megawatts, are proposed to be sited in South Carolina. In its post-solicitation reports, Charles River characterized the 23 program as highly competitive and concluded that the resources selected represented the highest ranked, least cost portfolio of options available to customers to achieve the target megawatts across tracks, technologies, and balancing authority areas, and the selected resources were the result of a fair process that properly weighted economic and non-economic factors in the selection of proposals. This concludes my summary of my direct testimony.
Thank you, Mr. Brown. Mr. Grinstead, could you please state your name for the record?
Tyson Grinstead.
And by whom are you employed and in what capacity?
I'm the State Energy Policy Director for Duke Energy.
Did you prepare or cause to be prepared under your direction 22 pages of direct testimony pre-filed on August the 15th of 2024?
I did.
If I asked you all of the questions contained in your pre-filed direct testimony here today, would your answers be the same?
Yes.
Do you have any changes or corrections to your pre-filed direct testimony at this time?
No.
Chair Powers, I would move that the pre-filed direct testimony of Mr. Tyson Grinstead be entered into the record as if given orally from the stand.
The pre-filed direct testimony of Mr. Tyson Grinstead will be entered into the record as if given orally from the stand.
Thank you. Mr. Grinstead, did your pre-filed direct testimony include one exhibit labeled Grinstead Exhibit 1?
It did.
And Chair Powers, I move that exhibit labeled Grinstead Exhibit 1 be entered into the record as the next hearing exhibit.
The pre-filed exhibit of witness Grinstead, identified as Grinstead Exhibit 1, marked for identification. We place the record as Exhibit number 3.
Thank you. Mr. Grinstead, would you please present your summary of your testimony at this time?
Absolutely, and good morning, Commissioners. My direct testimony supports the company's request made in their July 1st, 2024 application and generally introduces the company's 2023 CPRE program, including discussing the results of the bid selection process and the findings contained in independent evaluator Charles River Associates post-solicitation report. My direct testimony also discusses why the companies believe that our application and pre-filed testimonies support a commission finding that the 2023 CPRE program is in the public interest for South Carolina. Section 1 of my testimony provides a high-level overview of the company's 2023 CPRE program, which uses the same general commission-approved framework that the companies use to develop and execute their 2022 CPRE program. As Witness Brown explains, new for the 2023 CPRE program is the procurement of solar plus storage facilities, which provides for the company's procurement of utility-scale solar plus storage facilities that will have dispatchable, grid charging, utility-controlled energy storage capabilities. While procuring resources of this type is a first for the company, solar plus storage facilities help mitigate the intermittency risk associated with solar-only facilities and will promote system reliability. Section 2 of my direct testimony explains why the 2023 CPRE program is appropriate and benefits South Carolina customers. My direct testimony explains that the company's balancing area-wide competitive solicitations allow the companies to procure new, competitively priced solar resources identified as needed through their ongoing integrated resource planning process. I highlight the significant demand for new solar and solar plus storage facilities in the company's balancing authority areas and explain that integrating new solar resources to the system provides significant benefits such as reducing the company's reliance on volatile fuel prices and enhancing grid reliability by pairing solar with battery energy storage. My direct testimony recommends that the Commission find that the 2023 CPRE program is in the public interest, complies with South Carolina Code Annotated Section 584120E2 and Order Number 2024-141, and is consistent with South Carolina law and regulatory policy to the benefit of South Carolina customers. In Section 3 of my testimony, I discuss the findings contained in the independent evaluator's post-solicitation report. I note that the post-solicitation report confirms that the 2023 CPRE program was fair, open, transparent, and non-discriminatory procurement. The post-solicitation report also confirms that the 2023 CPRE program design and documentation were consistent with industry standards and precedent, and the solicitation itself was competitive. Finally, I explain that the results and conclusions contained in the post-solicitation report should give the Commission and stakeholders confidence in the integrity of the company's process to procure solar resources. This concludes the summary of my testimony.
Thank you, Mr. Grinstead. Ms. Smith, could you please state your name for the record? Thank you. And by whom are you employed and in what capacity?
Turn your microphone on.
Sorry, Heather Shirley Smith,
And by whom are you employed and in what capacity?
Duke Energy, and I'm Vice President of Regulatory Affairs and Policy for South Carolina.
Did you prepare or cause to be prepared under your direction 7 pages of settlement testimony pre-filed on December the 17th of 2024?
Yes.
And if I asked you all of the questions contained in your pre-filed settlement testimony here today, would your answers be the same?
Yes.
Do you have any changes or corrections to your pre-filed settlement testimony at this time?
I do not.
The Chair Powers, I move that the pre-filed settlement testimony of Ms. Smith be entered into the record as if given orally from the stand.
The pre-filed direct testimony of Ms. Smith will be entered in the record as if given orally from the stand.
Thank you. And Ms. Smith, would you present a summary of your testimony at this time, please?
Sure. The purpose of my settlement testimony is to explain the settlement agreement filed on December 4th, 2024 between the companies and the Office of Regulatory Staff. On behalf of the companies, I believe the settlement agreement is in the public interest for South Carolina customers, and the company respectfully requests that the Commission approve the settlement agreement. If approved, the settlement agreement resolves the requests made in the company's application and all outstanding matters, which includes ORS's motion for declaratory judgment and motion to strike, as well as the positions raised by other parties. I would also like to note that while SECIBA is not a signatory to the settlement, my understanding is that it does not object to the parties' agreement. My settlement testimony provides an overview of the settlement agreement and explains the agreement, the parties' agreement that the Commission, pursuant to South Carolina Code Annotated 584120E2, has statutory authority to review the company's proposed 2023 CPRE program and determine whether the program is in the public interest for South Carolina customers. My settlement testimony also explains that through the settlement agreement, the parties agree that the Commission can exercise the same authority as it did in Order Number 2024-141 to review and make determinations about the company's 2023 CPRE program. In addition, my settlement testimony explains that the agreement memorialized, 1, that the company's CPR procurement must be driven by a need identified in an integrated resource plan or similar planning process, and that the companies are afforded the flexibility to identify renewable resource needs and the timing to efficiently manage procurements on an ongoing basis. This flexibility is important to the companies because they are experiencing strong and unprecedented economic development and view the procurement of solar and battery energy storage resources as a growing part of the company's overall generation mix and near-term action plan to serve customers. That the 2023 CPRE program is reasonably informed by the company's IRPs and the company's commission-approved framework for implementing CPRE programs as approved in Order Number 2024-141. As a result, the parties agreed that the 2023 CPRE program is a reasonable step for the companies to take towards procuring renewable generation identified as needed in their resource planning process. 3, that the Commission's approval of the 2023 CPR program and the settlement agreement will be relevant to future siting and rate proceedings, but an approval of the 2023 CPRE program does not relieve the companies from any obligation to file Siting Act applications, to construct a proposed generation facility, and does not alter the general rate-making processes pursuant to South Carolina Code Annotated 5827-870 and 5827-865. Under this term, the parties agree that the companies retain the flexibility and responsibility to prudently effectuate, complete, or abandon the 2023 CPRE program and, as further detailed in the settlement agreement and my settlement testimony, the companies will keep interested parties apprised of activities related to any projects procured through the program. In closing, I believe the Commission should conclude that the settlement agreement is in the public interest for South Carolina because it provides constructive, although not dispositive, support for advancing new solar and solar paired with storage for South Carolina customers. It supports judicial efficiency and economy while also providing the Commission the full opportunity to ask questions about the company's 2023 CPRE program, and it's constructive for the company's efforts to plan and competitively procure the new renewable generation identified in the company's recently approved IRPs. The companies appreciate the opportunity to work with ORS to reach this constructive outcome, and the Commission's approval of the settlement agreement will provide the companies with a reasonable step toward procuring renewable generation to serve all customers within the company's dual state balancing authority areas. This includes my settlement testimony summary.
Thank you, Ms. Smith. Chair Powers, at this time, Mr. Brown, Mr. Grinstead, Ms. Smith are available for questions.
Thank you, Mr. Haber. First, is there an agreement about whether or not the parties want cross-examination or have questions or waiving that?
Yes, Mr. Chair. The parties will not be crossing each other. The only opportunity for questioning is potential redirect based upon Commissioner or other people's questions.
Mr. Witt, do you have questions? Or
Chair Powers, we're not in that agreement, but we do not have questions for this panel.
Thank you very much. Ms. Smith, I know in your testimony you said that we could have the full opportunity to ask questions later. I'm imagining some of this crowd might have some questions now, so we're going to turn it over. Any commissioner questions?
Chair Powers, yes, I do.
Commissioner Caston.
Still morning. Good morning. Under Section 7D of the proposed settlement, it states that the company's CPRE procurement must be driven by an integrated resource plan or similar planning process. I was thinking about that phrase. Does Duke have a similar planning process to the IRP for the CPR procurement, but not the IRP?
Sir, from the company's view, that could include an IRP update. So we go through, an annual process. You can have a comprehensive settlement agreement like the commission just approved, or we also have an IRP update approved, or if the market changes significantly and we need to rerun analysis, that's something we might need to do. We didn't need to do it in this case, but that's something we might need to do. So it's that quantum of analysis is what we take away from that section.
What I think I'm hearing is it's not a separate planning process, but basically IRP.
Yes.
And its updates.
Yes.
And that statement's basically saying that the CPRE procurement process or whatever should be consistent with the IRP.
Yes.
Is that correct?
Yes.
Under Section 7H, the settlement agreement states that if the commission approves the 2023 CPR program, it shall not equate to the approval. It shall not equate to the approval of and shall not be used as dispositive evidence of the following activities. And then it lists reasonable imprudence of any specific project, future recoverability of specific items of cost, and pre-approval of rate-making treatment. If there is commission approval of the 2023 CPRE, this will not be positive evidence in these activities. So without asking for information, pertaining to any settlement negotiations or anything like that, can you clarify, what's meant or what you mean by the term dispositive?
Sure. I certainly can give the company's view of these provisions, and that is just simply stated, H talks about what the approval would not mean, and I talks about what approval would mean. So H is that the approval would not mean, dispositive determinations of those three factors in subsection H, but approval would mean that what comes out of this docket is relevant to future proceedings. So relevant, not dispositive, is how I read those two provisions together.
Okay, let's drill down on that some. And as I understand dispositive, at least what it means definitive, or this seals the deal, the evidence is overwhelming. Something along those lines. Is that a fair assessment?
I think when I look at these provisions, this approval of the CPRE program is an important step on the continuum. We plan, we execute, we have various dockets that we bring before the commission, and then we place assets into service and come in for rate cases. So we have all of these steps. So that these steps are not singularly dispositive, but they are important milestones and they're relevant to one another. So approval of the CPRE program would not be the end-all be-all. We would still have to come in for Siting Act applications, for example, if a project triggered Siting Act approval. We still have to make our showings in rate cases. And we still, if the commission approves the CPRE program, the day after the order comes out, we are still subject to acting prudently, to managing the execution of the CPRE program, to make well-informed and reasonable decisions for customers from the day the order comes out on throughout the process as these selected projects advance.
Okay. I guess what I'm trying to be definitive about, what my understanding is of dispositive. It's not the same thing as persuasive or circumstantial evidence or terms like that. Is that fair? Is that a fair statement?
Yes, I mean, I'd certainly leave it to council, but I think we're looking at this as more probative than dispositive in terms of evidence.
Can I help you out a little bit? Can I ask a clarifying question?
Absolutely. I can always use
Under these terms, would it be a fair statement that Duke could not show up at a rate case hearing and say, you approved this in the CPRE, therefore we get cost recovery with no further showing?
Correct.
Or similarly, Duke couldn't show up at a citing case and said, you approved this in the CPRE docket, therefore you have to cite this without any further showing.
Correct.
Is that what y'all are saying?
Correct. We do believe the approvals are relevant as a part of the commission's overall consideration in those cases in the future. But we don't get to, we would not get the opportunity, and nor did we really seek the opportunity to say, we're done from this day forward for those future proceedings.
Duke understands that they still have to come in these future proceedings and prove their case and carry the burden of proof in those cases to what is being sought. Is that correct?
Yes, Commissioner.
Thank you.
Thank you, Commissioner Belcher. And thinking about that, relevant, which that was actually one of my questions or thoughts, that it's relevant. But what does that mean? Would that mean that, approval of this could be relevant in the sense that those terms, persuasive or circumstantial, would that be a view Duke may or may not have?
I think it'll depend upon the facts and circumstances of the cases that we file in the future. So I'm a little reluctant to be too speculative, but we do think that in considering whether to cite any of these projects or when cost recovery time comes, we do think it's relevant that we were transparent, that we had important milestones along the way, and that we are executing on what we said we were going to do. Or if we're not executing on what we said we were going to do, then we have a robust and reasonable explanation for why we departed. So I hope that answers your question.
Kind of. So how would approval or disapproval or just accepting this for information only affect future citing and rate proceedings?
I think it is an important data point for the company to obtain CPRE program approval. That is an important data point that I believe is and should be relevant in a citing act proceeding. But there are other significant showings that the company has to make under the citing act as part of a comprehensive citing act proposal. So this is a piece of information that would be important to that process, but not the end-all be-all answer to that process.
So, and don't let me put words in your mouth, Mr. Grinstead. If I heard you, that you gave your synopsis or overview of your testimony, basically the company believes from the company's perspective for the company and for the public, it's in the best interest and a host of other things you said about that. Is that a fair, very generalized
That's
statement?
fair. The way I would look at this, Commissioner Caston, at the risk of oversimplifying it, when you look at solar, the CPRE is largely about the process, not necessarily about the final outcome of each individual project. So if you remember, I testified in the Robinson Solar case. That was a siting act that flew from the previous CPRE down into a specific project. So I think what we're trying to get at is that what we really want is sort of a understanding from all stakeholders, from everybody involved, that the process is a good process. So that's how I would attack that.
Okay, and I guess what I'm trying to understand now, what I've tried to understand in the past, is the procurement, CPR procurement framework, you know, which Duke requested, and I think that was approved, you know, how you do it. And if the company believes that paired solar is certainly something they need, it's in the best interest of the customers also, from a cost and reliability and all that stuff. Then if the company believes that, and if the commission chose to say, hey, look, we agree with, you know, your framework, then relative to appreciate the information. You know, if we just took it for information only, why would, I understand you said data point, but if the company believes this is in the best interest of the company and the public, why does it matter?
Well, I don't think you want to get on down the road and have people question the process part of it. I think it would be good for in a general policy environment to have stakeholders on board knowing that this is a fair and balanced and reliable process. So I think, in other words, I think once we get to the rate case, you know, you can talk about the end all be all projects, but you want some buy-in on the process. You want stakeholders to be able to be involved. You know, you had Charles Rivers and Associates kind of there all the way, that independent evaluator. And, you know, you want the solar companies and ORS and others, you know, at the table and to have, you know, that trust and confidence in the process along the way.
But with the already approved framework, the company's framework, does it not already provide that in the framework sense? You know, stakeholder feedback, you do this process, and I don't know that there's a issue with that.
Well,
am I wrong?
Yeah, and my other witnesses can jump in as well. And I think Witness Brown talks about this, but I think the difference is this has material changes from the previous CPRE.
Yes. So the way I would categorize what we're trying to do here is to make sure the commission is aware of the process that we undertook, and to be comfortable that this portfolio of projects that were selected in accordance with the framework, and also we're providing more specifics on what those resources are than what the framework has, because the framework is a general framework. And because this is a large procurement, I think the companies, I used to work for the companies, but I would say the companies want to make sure that the commission agrees that the process was a good one.
I would also say that the 584120E2 describes competitive procurement program. It programs. It does not mention the framework. I think the framework is a piece of the programs, but in our mind, the framework is important to how programs are structured, but framework and programs are not synonyms in our mind.
Okay. But we keep talking about process, procedure, and I'm not aware that any of that's changed since the beginning.
Well, there are facts around the process. So we have a process of an independent evaluator, but the framework alone doesn't give you what the independent evaluator found, what the independent evaluator concluded from the bids, from the process, from how the company evaluated the projects, and that's the kind of information that we have filed in this docket.
And I may have misunderstood what Mr. Brown said, but the way he said it almost sound to me, again, as though the company's asking for pre-approval of a project or this type project rather than if the company thinks this is good, in the best interest of the company and the public, you know, okay.
Well, the company isn't asking for pre-approval of any specific projects. I think the company would like the commission to agree that, as spelled out in the independent evaluator report, the process was fair, transparent, and it was robust. So we were able to source a portfolio that was competitive and the best available. And it was aligned with our resource planning needs. But any specifics on any specific asset recovery or PPA expense recovery, that would be, only occur in a rate proceeding, whatever the appropriate rate proceeding is.
All right, I have no more questions at this time. Thank you.
Thank you, Commissioner Caston. Any other commissioners' questions? Commissioner Williams.
Thank you, Chair Powers. Good morning. This has been really helpful, hearing your testimony this morning. I'm going to go back and delve a little bit more in the settlement agreement and kind of want to take you to J and to the meaning of it. Is it true that basically does it say that the approval of the 2023 CPRE program is entirely unbinding on the company?
I wouldn't read it that way. I believe the CPRE program is an important milestone, much like the IRP is an important milestone for the company. I mean, we need these mile markers as we move along on our journey to serve customers. And so we're asking for the commission to approve the settlement agreement and conclude that this is the CPRE program is an important step to procuring the renewable energy identified in the IRP. But if facts and circumstances change after the commission's order, we are still obligated to make good decisions. We're not, it's very clear that we're not bound, and we're not asking the commission to bind us to execute on projects at any cost or no matter what might change in the world from the date the order comes out forward. We still are on the hook to prudently manage the process, construction, and everything that has happened up to this point from now until the facilities are constructed. You know, some of these facilities may not come online until 2028, 2029, or after. That's part of the interconnection process, which also identifies necessary transmission upgrades that will be, made to incorporate the solar onto our system. So, sitting here today in 2025, we think that now is the time that we're making decisions. Now is the time that we have the independent evaluators report. And so this is a good milestone to look into what we're doing at the time we're doing it, and what are the facts and circumstances and evidence that we have available to us at this time. We still have to make a required showing in those rate cases that come later, but that's a significant passage of time, and so we think it's reasonable and consistent with South Carolina law that we avail ourselves of the opportunity to seek commission review and approval of what we're doing.
So if the settlement agreement is approved, would it support the company's case in future proceedings?
I think if everything went perfectly, it would support the company's request in future rate cases. If the world changed or if there were surprises along the way, I think it actually sort of heightens the scrutiny of the company that would be applied to the company. You know, you did this under these circumstances. The world changed. Did you make good decisions about staying the course, or should you have gotten off the road? So, so I think it goes both ways.
And under 58-4120E2, would you agree that the commission has the authority to create CPRE procurement programs, but also has, or to approve CPRE procurement programs, but also has the discretion whether it chooses to approve, disapprove, or simply accept them for informational purposes?
I think that the commission certainly has the authority to approve or not to approve. I think if the General Assembly has given us a path to seek approval, then it's a lawful request for the company and to seek approval from the commission. And so it's unclear to me if the commission has the authority and the companies seek the that authority be exercised. I'm not sure. I think that's more of a legal question about whether accepting for information versus approval is appropriate. I think there may have been an oral argument on that. But I also think that those arguments have been resolved in the settlement agreement. So since now that we have an agreement on what approval in this case would or would not mean, would not be dispositive, but would be relevant to future proceedings.
Thank you. So the CPRE statute applies to renewable energy facility. The term's defined in 58-411012, and I'm going to read that. Renewable energy facility means a facility for the production of electrical energy that utilizes a renewable generation resource as defined in section 58-39120F that is placed in service after the effective date of this chapter and for which costs are not included in an electrical utilities rates. So my first question has to do with, so going further, 120F talks about renewable generations resources, solar, photovoltaic, solar and solar thermal resources, wind resources, low impact hydroelectric resources, geothermal resources, tidal and wave energy resources, recycling resources, hydrogen fuel derived from renewable resources, combined heat and power derived from renewable resources, and biomass resources. The point of all that is to ask, whether solar photovoltaic and solar thermal resources that you're talking about, I want you to, I guess, amplify the role of battery pairing with battery and how that fits that definition and goes back to the CPRE.
Sure.
And that question's for any of you that want to amplify that, because I'm seeing a lot of heads shaking up and down.
Sure. I'll walk through the references that you mentioned. There are definitional references that support what we're asking for, as well as practical. And so renewable energy facilities comes from 58-4120E2. That's the piece of code that talks about the Commission's approval to approve competitive procurement programs. That statute mentions energy and capacity from renewable energy facilities. So then when we go to 58-411013, that's where renewable energy facility is defined, and that provides for a facility for production of energy, electric energy that uses a renewable generation resource as defined in 58-39-120F, as you mentioned. So then we go to 120F, and that's from Act 236. So this is incorporated by reference. And when I look at 58-39-120F, It talks about a facility that generates electric power by the use of a renewable generation resource. There's a variety of those. That was placed in service for use or to provide power to an electrical utility after January 1, 2014. This is the important part in my mind. A renewable energy facility shall also mean any incremental capacity installed after January 1, 2014 that delivers energy from a renewable generation resource. The batteries are capacity. They are charged by the paired solar. So the batteries are incremental capacity that deliver energy from a renewable generation resource. That's the paired solar. And so that's why I think definitionally we're in good shape. And we, to be honest, probably could have done a better job as rereading the application. We probably could have spelled that out a little better. Zooming out 10,000 feet, the competitive procurement statute is embedded within the avoided costs piece of Act 62, the PURPA piece of Act 62. And so it is common in PURPA space for renewable and storage to work together because and this makes sense from a policy perspective, so it's recognized by the federal policy, but also it makes sense because paired storage allows you to access that renewable energy at times that you wouldn't otherwise be able to access it. So it's different than grid-tied storage, which is tied directly to the overall grid. For paired storage, it's part of the facility. It's kind of like I have a refrigerator, but my refrigerator is still a refrigerator even though it has a freezer component as part of it. So these facilities are one facility. So in retrospect, maybe we shouldn't be saying solar plus storage or solar paired with storage because that suggests that they're two different facilities. But they're part and parcel of the same facility. They connect to the grid at a single point of interconnection and are studied that way. So the renewable energy facility contains storage much like a refrigerator can contain a freezer. And I invite either of my panelists to supplement that.
You're really good at analogies, by the way.
Thank you.
So could the storage be paired with any other generation like hydro or coal, gas, and be pertinent?
Probably not under CPRE, but if you think about Bad Creek combines renewable energy as well as storage from a different technology perspective. It can also be charged from the grid. It was originally created for excess nuclear, like at night, but now even solar helps charge the pump storage at Bad Creek. So it's really the magic of storage overall. But it can matter what charges a battery, and so with solar plus storage that are part of the same facility, we know that battery is discharging renewable energy because it's paired with a facility that allows it to store it.
Okay. And you and I have both referenced 58-4120E2 and the relevant part of let's see. So in the definition, 58-4110-12 and the renewable energy facility definition, and you were referencing earlier, well, no, I think I was referencing the end of that, talks about that is placed in service after the effective dates of this chapter and for which costs are not included in an electrical utilities rates. So talk to me about how that definition relates to the utility owned portion of the 2023 CPRE application.
I have the definition of facility in front of me. I don't have 12. I might have 12 in front of me. Let me look. I don't have that. Oh, okay. Are you talking about 39-120? I'm sorry.
No, I'm actually talking about 58-41-10,
Yes.
number 12.
Okay.
The end of the renewable energy facility definition.
I don't have the full, I have the excerpt that talks about incremental capacity. I don't know if we have a code book. I'd be happy to.
Commissioner Williams, could you read that?
I'd be happy
section?
to. Okay. What? Chair Belzer's offering her, Commissioner Belzer's
Sure.
offering her code.
Okay. So I'm at 58-41-10.
Number 12.
12, yes. So renewable energy facility means a facility for the production of electrical energy that uses a renewable generation resource as defined in 5839-120F that is placed in service after the effective date of this chapter and for which costs are not included in an electrical utilities rates. So is that the section you're talking
Yes.
about?
Thank you.
So that, to me, this means a facility as defined in 5839-120F that does not exist at the time this chapter was enacted, which none of these did, and for which costs are not included in electrical utilities rates. None of these are used and useful yet, and so they're not included. The cost of the facilities are not included in our rates. If I go to the statute incorporated by reference, 5839-120F, that's where it picks up the solar, that solar can include storage, because it has that last line about a renewable energy facility shall also mean any incremental capacity installed after January 1, 2014 that delivers energy from a renewable generation source. So those two work together.
I think you answered it when you said the costs are not included yet. And that's where my consternation lies. So I appreciate your answer, and I appreciate all of your answers and your being here. Thank you.
Thank you. And I appreciate the Commissioner's Code Book. Thank you.
All right, ladies and gentlemen, I'm taking over for, briefly taking over for Chair Powers until he returns. Are there any more questions for the panel? All right, hearing none is.
Chair.
Oh, I'm sorry.
I was a little slow on the draw.
Oh, okay. I'm sorry about that. I can be a little quick on the draw. Commissioner Thomas.
Thank you. When you were talking about Section 7H of the settlement agreement, and there was discussion about the word dispositive, and then I think I heard you say it was more probative. I don't know. That just causes confusion for me. How do you get from dispositive to probative?
Under the settlement agreement, the Commission's order is not dispositive, but it's relevant to future proceedings. And when Commissioner Cassidy was asking me about what relevant meant, and he gave me a list of additional concepts, the closest I think of in terms of relevant might be probative. But the words of the settlement are relevant, meaning it matters. What we're doing here should matter to future proceedings. It's not the end-all be-all. It's not dispositive. But the decisions that we're making along the way, whether it's in the resource plan or as we're acting upon fulfilling the needs identified and the way that we're fulfilling those needs, where we are at the time we're making decisions matters in future proceedings. It'll be relevant.
All right. And again, there's been a lot of discussion about such things as approve versus accept. And I'm still not sure that I understand why it's so much more important to approve as opposed to just accept this agreement.
Well, I think, first of all, it's the company's position that it's within the commission's authority and our commission to ask for approval, and believe that's what the operative CPRE statute says. But it's also important for Duke as a company to understand where we are along the continuum of planning and executing and operations. We think it's important. If anyone thinks that we should not be deciding and making decisions to procure renewable energy at this time, this process gives them a chance, including the commission, to render that opinion. It's important for us at the time that we are making decisions to understand the views of stakeholders, which is why we stakeholder engage on this, which is why we think a proceeding with intervention is important, and why we think it's important to come before the commission and answer questions and get clarity that what we're doing is a reasonable step. And that's why the reasonable step language is all from the settlement agreement is also important to us.
All right. Thank you. Appreciate that.
Thank you, Commissioner Thomas. Commissioner Belser.
Thank you. Lady and gentlemen, thank you for your testimony this morning. I just have a couple of things I want to clarify, if you don't mind. With regard to this question of probative versus dispositive, when the company comes in for recovery of cost, what is their burden that they have to meet at that time?
The companies have the burden of proof.
Reasonableness and prudency, would you agree with that?
Yes, I do.
And how is prudency looked at the time that the commission must determine whether the company's actions were prudent or not?
In regulatory frameworks, the decisions that an entity makes, the decisions that a utility makes, are judged at the time it's making the decision.
Based on the evidence they have at that time. It's not based on what has happened in the interim and between the cost, when cost recovery is sought. Is that correct?
Correct.
So does it assist for the company to have some certainty as they move forward?
It does.
Okay. But just because the commission is approving this, or if the commission does approve it, just because that happens, that is not the end of the inquiry at the time that rates are sought. Is that correct?
It is not. There's a
Okay.
lot of road in between approval in this docket, if the commission grants approval, and when we come back in for future stops along the way, like citing act cases or rate cases.
So when you're talking about probative versus dispositive, does the fact that the company may come in and ask for approval and provide the commission with information on what they know at this time, is that probative later, even though it's not going to say, well, y'all approved it, therefore give us the money?
Yeah, I think under the settlement agreement, it's relevant. I don't want to get wrapped up around relevant and probative. Probative was my word. The settlement word was
It's relevant.
Relevant.
It'll be relevant
yes.
evidence, but not the end of it.
Yes.
Okay. This application was filed last July 1, I believe, July 1 of 2024, and Mr. Brown and Mr. Grinstead's testimony was filed in August. What's the status of the program, of the CPRE program now that it's into January?
Okay. So we have had 1,412 megawatts that continued on in the program after we went through the interconnection study and we went through the bid evaluation process. That's how much was actually that was proceeding into development. Subsequently, two projects have actually dropped out since that time, but the remaining projects are continued in flight, and they anticipate they'll probably be, some of them might be online in 2027. Most of them will be in 2028 or beyond.
Thank you for that update. I appreciate that. That's all I have, Mr. Chairman.
Thank you, Commissioner Belson. Commissioner Caston.
Thank you. Just, I guess, to kind of follow up, if it's okay, Ms. Smith, I think in a response to Commissioner Thomas, this will not be an exact quote, but you said something about the importance, I guess, to the company. If anyone, the commission, thinks that solar paired, you didn't say not good, but do you remember what you said?
Well, I remember what I meant. I may not remember my exact words, but we're actively in the process of procuring solar to serve our system, including South Carolina customers. If somebody thinks we shouldn't be doing that, a stakeholder, an intervener, the commission, we think that's really important for us to know. And these proceedings give entities a chance to express that, ask questions, and really kick the tires on what we're doing. Is what we're doing the right thing to be doing at this particular time?
Okay, and I appreciate that. Thank you. Because you know what kind of went through my head when I heard that, and I probably in the past before, is, absent, some statutory requirement that says, all right, commission, they got to have X amount of this, X amount of this, X amount of that. Personally, I don't feel like it's my role to tell you what resources or what you're supposed to do. You're the experts. I know I'm not at that. So I guess I'm still kind of wondering where to land on that, and that if the company thinks this is the best thing to do, best cost, most reliable, and all those other things, then, whether it's, again, whether it's approved or we say, thank you, appreciate your thoughts, kind of like the RRP. I'm trying to somehow wrap my head around, why do we need to approve what resource you're going to use now? It's great information, and if the company thinks it's what you need to do, you ought to do it.
Well, I don't think that, I can't recall in Act 62 where there's language about accepting. I am thinking of language about approval. So the commission approves IRPs or not. They're not dispositive for rate making or execution activities, or not determinative. I think that's the exact statutory language, but we view that as an important milestone. We identified 17,000 megawatts of solar for a 15-year period, and a sub part of that, around 6,000 to procure through our near-term action plan. This is a piece of that plan where we sought around 1,400 megawatts. And so, coming with a program of how to do that, that allows us to seek and obtain commission approval for those programs, we think that's a reasonable thing for us to do and a reasonable matter for the commission to take up.
I understand. But when I think in terms of the IRP, which I agree, it's a high-level plan, and this is what, at the time, the company believes they need. But I was trying to think of anything else that the utility relative to that comes in and say, hey, we need to extend this distribution line, transmission line. We're thinking about adding this gas facility or whatever. This seems uniquely different in that specifically soliciting a distinct response for just this, which is in the IRP, I assume, you know, if you've got so much tentatively planned in the RFP, did that make sense?
Yes, I mean, I think, I think if the company, it is incumbent upon the company to act in the best interest of customers and stakeholders and a variety of considerations. And not everything is jurisdictional before this commission. Not every decision we make is jurisdictional before this commission. But where the General Assembly has given the commission the power to approve something, we think that it makes sense for us to come in for that approval and to seek that approval, and for us to understand where we are along the continuum of serving customers over the longer term horizon. We're making some awfully important decisions on how to serve customers, and knowing that that we're taking reasonable steps at the time we're making them, taking those steps based on the information that we provided and that's available to us in the commission, that's a pretty good gut check, we think, and something that is statutorily enabled.
Okay. All right. Thank you, ma'am.
Thank you, Commissioner Caston. Any further commissioner questions? Commissioner Thomas.
Could we take about a 15-minute break?
Certainly. Well, I'll tell you what, it's about 18, 19 after. Let's come back at 11:30. Is that enough?
Yes, sir.
Thank you very much. We're in recess for just a few minutes. We are back on the record on docket number 2024-144E and are having commissioner questions of the panel that has been proposed and put forward by the company. Is there any further commissioner questions at this time? I'd just like to ask one thing. With any project you have, you're going to have to check off all the boxes, meet all the elements of the Siting Act. Is that correct, Ms. Smith?
For those cited in South Carolina, yes. Some of these projects will not be cited in South Carolina, but it's not codified, but we still have due diligence and important decision-making points that will be important when we come back before y'all with costs for those projects.
And will ORS have the opportunity to review any of these projects in time and availability to them?
Yes, and if I might add, sir, I think that's another thing that really commends the settlement is, I've discussed a few minutes ago about how we have, an obligation to continue to act prudently in managing these projects and deciding, making decisions along the way. And the settlement agreement in Section A also requires us to keep the ORS and you informed as to how things are going. So Section I requires, for informational purposes, that we provide annual information on project status, project development updates, any schedule delays different from the assumptions in the docket, any material changes in assumptions or pricing that may be different from what's been reflected in the docket. So people aren't going to have to wait years from now to know how things are going.
Would that provision specifically, would you agree that provision's focused really on the transparency for the commission and ORS to know what's going on?
Yes, sir.
Do you feel that provides the same transparency for other stakeholders and other people maybe involved in the case?
Yes, sir.
Okay. Without the settlement agreement, would the companies have been required to provide the agreed upon updates to ORS Commission?
It would not have been required, no, sir.
That wasn't part of it?
Yes, sir, that was part of the negotiation process.
And that's one of the compromises that have come out of this?
Yes, sir.
Okay. Well, thank you very much. Any further commissioner questions?
Chair Powers.
Commissioner Thomas.
Thank you. So, in connection with the Siting Act and projects that may be located in North Carolina, obviously they don't come before us, but if a project is in North Carolina and it will be considered in a rate case just the same as if it were in South Carolina. Would you agree with that?
Yes, sir.
Thank you.
And subject to the same reporting. That's for all facilities, not just those located in South Carolina for subsection I.
All right. Thank you.
Vice Chair.
Thank you, Mr. Chair. Ma'am, gentlemen, thank you for being here. Ms. Smith, you've appeared before us several times as a witness and as counsel, and your colleagues to your left and your right, I welcome them to assist you in this question. Would you agree that you've been very transparent with us here today and through the course of this process?
Yes, sir.
Okay. And you've heard all the questions that have come from us, or my colleagues, I should say, up to this point, and you've responded to them fully and transparently. Would you agree with that?
Yes.
Okay. I'm going to ask you all to go a little bit deeper into what we have here before us today based on your experience since we started here at 10 o'clock. Do you sense at all that there's a level of concern about this settlement?
I sense that there is a desire for understanding how it will be used.
Okay. And based on that desire, you're in the moment, so you haven't had an opportunity to reflect and to watch the tape as I like to do once these proceedings conclude. but if you just stop and think about it based on me asking the line of questioning I'm asking now, how would you go about wrapping everything up in a way that would assuage those concerns or offer more to the commission to better understand exactly what the company is attempting to do here today?
Certainly, I'll start and I'll invite my fellow panelists to add on. In our application and throughout the process and in testimony, we've endeavored to be transparent about the differences between the 22 RFP and the 23 RFP, which we've underscored in our filing and through the testimony of Mr. Brown. We've also provided information on the benefits of the resources that we are procuring on behalf of our customers, how they fit into our overall generation mix, how they fit into our overall generation plan, what is the timing and the pricing that we're agreeing to, and the mix of resources that we're bringing online, as well as acknowledging our obligation and duty to continue to manage this process and these individual projects reasonably and prudently for customers, and that exists even if the Commission approves the settlement as a continuing obligation of the company. In reaching a compromise in this case with the Office of Regulatory Staff, we're hopeful that the Commission sees the merits of that settlement as it did for the 2022 RFP. And we hope that we've demonstrated that the settlement is a reasonable compromise between the parties, that it supports the development of resources that are necessary to serve our customers as part of an overall generation mix of various types of generation, and that it overall supports judicial efficiency and economy, because y'all are considering and having information contemporaneous with the decisions that the company is making. We believe that we've reached a good compromise that spells out the value of an order going forward, but also the limitations of an order going forward, that it's not dispositive, but it will be relevant in the future, as will our actions from the date of this docket on. And hopefully that gives the Commission peace in knowing where we are along our continuum of serving customers, from planning to procuring to executing. And I invite my fellow panelists to add anything to that statement.
Yeah, Vice Chair Williams, I think that hit the nail on the head. The only thing I would add, and I was thinking about this during the break, I felt like Commissioner Williams' questions were very important. And she asked about solar paired with storage earlier. That's exactly the type of question that we don't want to get 20 steps down the road and then have to figure out whether that was right or not, right? That's something that's very appropriate for the CPRE process and why we're here today. And that's the type of question we would want approval on now, rather than waiting on down the road for a legal question like that or interpretive question to come up. So in my mind, that's a great example of how this CPRE is different from the last one. The last one didn't have solar paired with storage. This one does. And there are questions around that. And I don't think we want to get all the way down to the end of the road and then have to figure those types of questions out. So that's the only thing I would add.
Anything to add? No. One other thing I would say is that the company is also very mindful of how quickly South Carolina is growing, how many people are moving to the state, how many businesses are locating in the state, and it's incumbent upon us to have energy to serve them. And this is a piece of that. Solar plus storage are resources that we can get onto the grid relatively quickly, and they're needed. In fact, these resources were not part of the near-term action plan, and the IRP talked about procurements 24, 25, 26. It was already assumed that we had this generation in planning for incremental resources. So I view this as making good on making sure that we have resources to serve customers. At the same time, we're bringing the solar online outside of this docket. We're also pursuing natural gas generation and other forms of generation to serve our customers. So, so I think all of that put together, this is a piece of the overall pie of our generation mix, an important one, and we hope that the Commission approves the settlement agreement accordingly.
Thank you. Mr. Grinstead, I appreciate you referencing Commissioner Williams' question. You know, I never really thought much deeply into the question, and maybe I just could have taken for granted the answer. But would you consider that more of a technical question that comes with a technical answer as opposed to that being a question about reasonable imprudence?
I think I would.
Okay. And I think this has been said several times. There's nothing before the Commission today, but I just want to make sure, since you pulled out that example, a real-world example from this proceeding, a question like that can be answered without answering or even asking a question about the reasonableness or prudence about pursuing such a technology or such a project. Is that fair to say?
I think that's right. And it was just an example, but I think that's right.
All right. Mr. Chair, that's all I have. Thank you.
Thank you, Vice Chair. Commissioner Caston.
One follow-up on something you said, Ms. Smith, just now, relative to, you know, the growth, not only population, but energy demand, you know, from industry and such, that these type resources are quickly done, quickly installed, I guess, easier to get. And I don't dispute that. I don't know one way or the other, to be honest. But with that said, when you said that, thinking about this settlement, whether it exists or does not exist, you know, whether this is, whether y'all are just sitting here telling us about this just for information purposes. And I'm not going to ask you to repeat all that stuff again. But if that is the case, and that is what the company thinks needs to be done, is the most prudent thing to be done, whether this is settlement exists or not, or whether it's just for information or not, how does that, what would that slow down or speed up?
Well, if the Commission did not find that our programs were in the public interest, it may affect our future procurements, or it may affect the allocation of what we view as the appropriate allocation of resources between North and South Carolina. So I think it's important for us, if we have the ability to file for a Commission approval of a CPRE program and a public interest determination, that we obtain that so that we understand where we are along the continuum. But this is the regulator's view of what we're doing at the time we're doing it is a very important data point for the company in decision making.
So what I think I just heard, you say that for this and any future CPR dockets, you didn't say that, but I'm assuming that. If it's a wrong assumption, I apologize. That you want to come to the Commission to get approval that these things are, I guess, reasonable. I'm trying to remember the exact word you use. And if the Commission just accepts this as information, are you saying that means we think it's not reasonable or prudent or just? Is that the purpose of these, to determine if it's just and reasonable?
I would have to leave it to our counsel, but I didn't read that as an option in the statute where the Commission can approve programs that it finds in the public interest. If we bring one and the Commission doesn't approve it, then I think the company would be evaluating whether that means that the Commission does not think that what we're doing is in the public interest and we need to be doing something differently.
So you're saying the CPR program for Duke means bringing all these to us. So we'll tell you, yes, we agree it's in the public interest, rather than what the original thing was in the CPR framework that said it's in the public interest for you guys to do what you're doing the way you're doing it.
Yes, and I believe that's what's in the CPRE statute. The word framework isn't in the statute. A framework's a part of a program.
I agree.
Part of
I
a
agree.
program. But it's not the commission's order on a framework is we don't think a public interest determination about a program.
Okay. And this process and this request for the public interest is unique for just this, for solar or solar paired. You wouldn't do this for any other generation source or such as that, correct?
Well, our ability in what we're doing is governed by the CPRE statute. In a Siting Act case, we would, part of the consideration is whether the facility is in the public convenience and necessity and environmental compatibility. So I think the findings for individual matters would be guided by what the relevant statutory authority would be, as well as the Commission's overall supervisory and regulatory authority. But all that's in front of the Commission today is our 2023 CPRE program, not the resources aren't even built yet. It's, approval of the program and where we are at this milestone in executing on bringing solar online for customers. It's our intention to come in annually because we anticipate that every CPRE program annually will have its own unique characteristics. I understand that maybe perhaps other utilities may not want to avail themselves of that option, but we intend to sitting here today.
All right, thank you.
Chair
Thank you,
Powers.
Commissioner Cass and Commissioner Williams.
Thank you, Chair Powers. I appreciate your answering Commissioner Williams's question as, that there's some deep interest in this program and its construct. And what I'm wrestling with is the question of, you've helped illuminate the company's perspective a lot. And what I'm wrestling with at this minute is in the CPRE statute, it focuses on the generic docket, and then everything that you have said after that makes absolute sense. But how does our approval or accepting for information or disapproval, how does that fit with the language of the statute? And I know I'm asking you a legal question, but to the extent that you've been able to answer these questions earlier, how does that relate to the statute's focus on a generic docket?
I think I can also answer it from a regulatory lens, having been involved in those matters, having been around and been involved and working on those matters. So we view that as the Act 62 afforded a generic docket. And so there were lots of meetings. There were lots of meetings after Act 62 was passed. There was a generic docket to me from a regulatory lens that made sense because that's how you get, a variety of entities at the table. It's not a utility-specific docket, a generic docket. There was a lot of information taken. And then that was, in my mind, the seeding ground for individual dockets. So coming out of that generic docket, the Commission also took up certain actions relative to CPRE programs, which the company, even in its, I think it was September 2022 or 23, I think it was 23, when we filed our first CPRE program under Act 62, that followed a series of orders coming out of that process. So I think that we're right in line with, starting at a generic docket, developing into programs, seeking programmatic approval, and that public interest determination. So I think in my view, we're tracking what was laid out in that section pretty well.
Thank you.
Is that all, Commissioner Williams? Yes, thank you. Any further commissioner questions? Any redirect from Mr. Hamer? Sure.
Thank you, Mr. Chairman. Ms. Smith, Commissioner Caston asked about exercising or receiving information instead of approving our application. Do you recall that line of questioning?
Yes.
I have on the Elmo a copy of the company's application. I direct you to the first sentence of the application. Is it your testimony, Ms. Smith, that the company submitted this application under Regulation 103-823?
Yes.
And pursuant to that, is it your testimony that the commission is authorized to grant this application and approve the settlement agreement?
Yes, and that something similar is contained in 7A in the settlement agreement as well.
Thank you, Ms. Smith. Nothing further, Mr. Chairman.
Thank you. Any further commissioner questions based on the redirect? Anything from anyone?
Nothing from RS, Mr.
Thank
Chairman.
you very much. Mr. Witt, anything?
Nothing for Sasiba.
All right. Well, thank you all for your presentation. It's very good hearing, I think, and everyone have a good day, and we're adjourned.
Thank you.